Cool. Hi, everyone, and thank you for joining today's session. My name is Alyse Lee. I'm a lawyer at Hannan Tew Lawyers. So before we begin, just confirming that this session is being recorded for those who aren't able to attend live. Just letting people in. Awesome. So we acknowledge the traditional owners of the land on which we are meeting on today, the Wurundjeri people of the Kulin Nation, and pay our respects to their elders, past, present, and emerging. Please note that the information provided today is general in nature and does not constitute legal advice. Every case is different, so if you have specific questions about your situation, I recommend seeking professional advice so that's tailored to your unique circumstances. So in today's webinar, I'll be covering key insights into the Skills and Demands Subclass 482 visa, which is currently the main temporary employer-sponsored work visa in Australia that allows a stay period of up to 4 years. If you have any questions throughout the session, you should be able to put it in the chat function on the side, and we can go through them at the end of the session if we have time. So the topics that we'll go through today, I'll be looking at what has changed for the 482 visa, the impact to the eligibility and visa requirements, impact on businesses and individuals, the visa conditions applicable to a 482 visa holder, and the relevant work rights. Next, I'll also go through the sponsorship and compliance obligations, as well as any frequently asked questions. So these are common queries and concerns that we receive from our clients, and how we, Hannan Tew Lawyers, can help and support you in navigating these changes effectively. So I thought I'd start as at the very first step. So before a business can sponsor a foreign worker under the SID 482 visa, they must first apply for and be granted a standard business sponsorship, an SBS. To be eligible for an SBS, a business must meet a few key criteria. First, the business must be lawfully operating in Australia. So this means they need to provide evidence of their business registration, financial standing, and ongoing operations. Secondly, they must demonstrate a commitment to employing local labour. So this means Australian citizens, permanent residents, before seeking to sponsor overseas workers. Thirdly, there must be no adverse information about the business that would impact their ability to be a sponsor. Adverse information could include any breaches of workplace laws, previous sponsorship non-compliance, or any financial instability. So the business has gone bankrupt, for example. Once granted, an SBS is valid for 5 years, so it allows the business to nominate multiple visa applicants within this 5-year period. However, the business must continue to comply with its sponsorship obligations, which I'll cover a bit later, within this period to maintain their approved status. So this first step is crucial because without an SBS, a business cannot proceed with the SID visa. So as some of you may be aware, the Skills and Demand visa replaced the temporary skill shortage visa on the 7th of December 2024 last year. The subclass number 482 remains the same. Much of the requirements is largely the same, but the biggest changes are there are now new streams. So the streams which were previously short-term and medium-term are now replaced with the specialist skills and the core skills stream. So I'll go through these in more details as well in the next slide. There is still a labour agreement stream, and that remains unchanged. The second biggest change is that the work experience requirement has been reduced as promised by the Australian government. Previously, an applicant will need to demonstrate at least 2 years of full-time relevant employment experience in addition to any qualifications for the relevant skill level of the occupation. This has now been reduced to 1 year and can also include casual paid employment. The third biggest change is that the occupation list, previously known as the short-term and the medium to long-term skilled occupation list, has now been replaced by the core skills occupation list, CSOL. Most of the occupations have been retained, but there are a few that have been removed or added in. So these are the 3 streams under the SID visa program. So the specialist and core skill streams are now in effect since December 2024. The Australian government has mentioned that they are developing what they are calling an essential skills stream. So this may replace the labour agreement stream. Further details are yet to be released. So this proposed essential skills stream will address critical labour shortages in Australia. It'll primarily target lower paid workers in essential roles. So this is occupations within the aged care, disability support. This also includes, it's very much under development. The government may expand the eligible industries and occupations based on labour market needs. So at the moment, what we know is that it really is focused in that aged care disability industry. So I'll go through in detail the 2 main streams. For the specialist skills stream, this is geared towards skilled professionals that are earning above $135,000 as their base salary. So this amount is currently the specialist skills income threshold. Any ANZCO occupations can be nominated under this stream, except for those that are listed under Major Group 3, that's the technician and trade workers, Major Group 7, machinery operators and drivers, and Major Group 8, which is the labourer's occupation. For this core skills stream, these are eligible for occupations that are listed on the core skills occupation list, or the CSOL. They will need to have an income above $73,150, which is the current core skills income threshold. So both of these streams can be granted for up to 4 years and can lead to employer-sponsored permanent residency, which is through the Employer Nomination Scheme, Subclass 186 visa program. The core skills occupation list was released on the 3rd of December 2024, and it mainly applies to the core skills stream. So the full list has about 456 occupations. There are 40 occupations that were on the previous short-term skilled occupation list and the medium to long-term list, sponsorable under the old TSS program, but are no longer included in the current list. So these occupations are no longer sponsorable under the current SID visa. So some of these occupations that's been removed is cafe and restaurant manager, conference and event organizer, customer service manager, specialist manager SNEC, ICT support manager, and graphic designer. There are, however, new occupations that have been added that weren't previously sponsorable, and some of these new occupations that appeared are those that were listed on the ANZCO ABS website when they updated the list. So these include data analysts, scientists, childcare worker, beauty therapist, cybersecurity engineer, DevOps engineer, retail engineer, and travel consultant. So where you believe any candidate is impacted or that your occupation doesn't fall into this list, please feel free to reach out to us in the first instance, and we can review and discuss any strategies or any alternative visa options. Generally, from a high level, with current 482 visa holders that are sponsored with an occupation that's not on the CSOL list, there is still a pathway to employer-sponsored PR through the 186 visa, and this will be under the temporary resident transition, the TRT stream, if they have met the 2 years with their sponsor in their current role. If they're not eligible for PR before their 482 visa expires, so if they haven't met that 2 years, then we can look at if the salary for their role is above $135,000. So obviously this is pending confirmation on the occupation, so it can't fall into those three categories I mentioned, the technician, trade workers, machine operators, and drivers and labourers. They could still be eligible to apply under the specialist skills stream. Another option is we could potentially look at whether another occupation that could align. So for example, if there are any role changes or upcoming promotions, we can review the position description and see if we can align it to an occupation that is sponsorable. It will still need to meet, it will still need to substantially align to the ANSCO occupation chosen, but we can definitely have a look at that. In terms of other visa options, we can explore whether the general skilled migration pathway or even any regional visas could be an option. So if you have any question, feel free to reach out to us. So the third stream that remains unchanged is that labour agreement stream. This stream applies where there is a work agreement negotiated with the Australian government where the standard visa programs like the 482 visa is not available. The main requirements is that the nominated occupation is specified in the work agreement. The requirements specified in the work agreement needs to be met, and also that they are available nomination places in the relevant ceiling year for the occupation. So if your business has a labour agreement that's currently in effect, you can look at whether you still wish to rely on this. You could if it is beneficial to the business. So for example, if it's an occupation that's currently not sponsorable under the CSOL, or it doesn't meet that specialist skills stream requirements, or you could choose to use the standard SID program. For example, there are no more nomination places that you have to be aware of. It could also mean quicker pathways to permanent residency for the candidate. With the visa requirements, a majority of the criteria still remains the same. The biggest change that we've noticed, as I mentioned earlier in the session, the work experience requirement that the main applicant has to meet has decreased from 2 years to 1 year. So that's a total of 12 months. And it can also now include casual employment. For occupations, these must be aligned to occupations listed on the CSOL if you're applying under the core skills stream, or otherwise the role must be earning above 135,000 to be eligible under the specialist skills stream. The applicants will still need to meet the skill level, so they will need to show that they have the relevant qualifications. Generally, this is a bachelor degree or higher, and experience based on the skill level applicable to the occupation. For example, if an occupation requires at least 3 years of employment experience, regardless of the 1 year requirement, you would still need to show 3 years to meet the skill level for the occupation. Labour market testing must still be met, and the individual must also be paid above market rate for the role in that relevant location. So I'll go through this in more detail in the next slides. From a visa perspective, the applicant will still need to meet health requirements, so they'll still need to undertake medical examinations as necessary, depending on where they have resided in the past 5 years, what passport they hold, and whether they have any health disclosures. They'll also need to meet the character requirement, so this means providing police clearances from all countries they have resided in for more than 12 months in the past 10 years. And this will also include Australia if they have lived in Australia. And it also depends whether they have any character disclosures. So this includes any spent convictions, any ongoing criminal investigations as well, even though it's not on the record. English requirements would also need to be met. So all individuals must now meet the vocational level of English. Previously, the short-term stream can meet the vocational level, and the medium term was also meeting the vocational level. Individuals would be exempt from taking this English language test if they hold a passport from the United Kingdom, United States of America, Canada, New Zealand, or Ireland, or if they're an intercompany transfer and will be remunerated more than $96,400 by the sponsor, or if they have completed at least 5 years of full-time study in a secondary and or higher education university where the medium of instruction was in English. Otherwise, they'll need to take an approved English test, such as an IELTS test, and score at least 5.0 for each of those 4 test components. Lastly, the role would also need to be a genuine position such that it truly exists and is consistent with the nature of the business. So, for example, it means that the role was not created for a migration outcome. The purpose of labour market testing, which is one of the requirements for the nomination application, is for businesses to demonstrate that they have tested the local labour market and could not find an appropriate Australian worker. Hence, they are sponsoring a foreign worker to fill that role instead. The main requirements for labour market testing, the LMT, is that there needs to be 2 advertisements posted live on a national platform such as Seek or Indeed for at least 28 days, and they will need to be valid for 4 months from the date of posting. It must also be posted after any retrenchments or redundancies if there are any. The ads must include the title, description of the role, skills or experience required for the role, the sponsor's name, where the role will be located, and salary if the role is paid less than $96,400. Once the 28-day period is over, the business will need to provide details about how many people applied through the ads, whether any were offered a role, and reasons why they were not chosen. The ads will need to be continuous or overlapping. If they are posted back-to-back or they don't overlap, it won't be acceptable for the application. The contract will also need to be signed by both the business and the applicant and be dated after the 28-day period is over. There are exemptions to the LMT requirement, so if these are met, then no advertising needs to be completed. The first exemption, which is rarely used, is where there is a major disaster that's occurred in Australia and that has a significant impact on individuals, that the government response is required and the sponsorship is necessary to assist in disaster relief or recover. It's not on the slide there because it's an exemption that's rarely and has a very high threshold, so it's rarely used. What I'll go through are the ones that are more commonly used in practice. So these are due to Australia's international trade obligations with certain countries. Firstly, where the applicant is a citizen of certain countries like Canada, Chile, China, New York, Singapore, UK, their passport will be sufficient to meet LMT. Secondly, if the applicant is a permanent resident of a certain country, such as Canada, Chile, New Zealand, Singapore, UK, evidence of their PR will be sufficient. Thirdly, if the applicant is a current employee of an associated entity of the sponsor, located in countries like Canada, Chile, China, Mexico, UK, New Zealand, or any Asian nation. So these are Brunei, Myanmar, Cambodia, Indonesia, Laos, Malaysia, Philippines, Singapore, Thailand, or Vietnam. Fourthly, if the applicant is an intercompany transfer from a World Trade Organization member country and is nominated in an executive or senior manager occupation, for example, a chief executive or managing director, chief information officer, CGM, CSM, finance manager, HR manager, and they will be responsible for a substantial part of the Australian operations or responsible for the establishment of a new operation of that business in Australia, they'll be exempt from LMT. And lastly, if the applicant is a citizen of a World Trade Organization member country and they have worked continuously full-time with the business in the nominated position in Australia for the last 2 years, they are also exempt. This usually applies where they already have a 482 visa and they're renewing their 482 visa for another 2 to 4 years. There are also LMT concessions where alternative evidence such as a submission from the business to explain why the specific individual is chosen. This is The first one refers to internationally recognized record of exceptional and outstanding achievement. So individuals that are truly exceptional in their field, so maybe a sports person, research person, or a top talent individual, then they are able to rely on this exemption. Secondly, if the individual is employed by a company overseas that's an associated entity of the sponsor, then we can rely on this concession. If a current 482 visa holder requires a new nomination to be lodged solely because their earnings have reduced, or if there is a change in business structure that resulted in a new application for the business to be approved as a sponsor, they can rely on this. Individuals that earns above $250,000 as their base salary earnings are also a concession. And lastly, if the individual is nominated in an occupation within the medical practitioner and the ambulance officers and paramedics ANSCO groups, then they will be exempt. Now, the market rates requirement. So this particular requirement is designed to ensure that overseas workers on the 482 visas are paid the market salary rate and that the visa program is not used to undercut the Australian labour market. Earnings for the purpose of the SID visa would include the wages of the applicant. So this refers to base salary in cash that they will receive and any agreed money value of non-monetary benefits. It doesn't include any payments that can't be determined in advance. It won't include reimbursements or superannuation either. For the core skills stream, so as I mentioned earlier, the salary must be paid above the core skills income threshold, which is $73,150 at the moment. Specialist skills stream, it's $135,000, which is the current specialist skills income threshold. The equivalent Australian worker must also be paid above these income thresholds if they are utilised as the market rates to demonstrate market rates. These two income thresholds are indexed, so they will be adjusted each financial year in line with the average weekly ordinary time earnings. So we'll likely know more what the increase would be in June, July 2025. If there is an enterprise agreement or industrial award that applies to the role, the business can provide this agreement or award and note which salary banding is applicable. If there is an equivalent Australian in the same role and location, so this refers to any Australian citizens or Australian permanent residents that is working in the same or similar role in that same location, then the business can provide a copy of the contract and or payslip. If there is no equivalent Australian, then they will need to show how the business determined the salary, providing alternative market data such as any remuneration surveys like Indeed, Talent, Seek, Glassdoor, or any advertisements for similar roles in the area. So what the SID visa that came into effect and what are the effects of these changes? The biggest effect is that they're meant to assist with streamlining the 482 visa program. So most notably, both streams now provide a stay period of up to 4 years. Previously, it's 2 years for the short term and 4 years for the medium term stream only. Now you can request for 1, 2, 3, or 4 years upfront. The English requirements are now the same for both streams, so applicants will need to show that vocational level of English. There is also now a consolidated occupation list. Previously, there were 2 different lists that we would have to refer to, and now the government lodgement fees are also the same, regardless of the stream that you're applying under. There are also clearer pathways to employer-sponsored PR. Both streams allow access to PR through the 186 visa program. So periods of any employment with any approved sponsor under the occupation that they're approved under will count towards the TRT requirements. Previously, the 186 visa was only available to 482 visas holders in the medium-term stream, and after the COVID pandemic, it was opened up to allow short-term 482 visas holders to have access as well, subject to them meeting the relevant requirements. Now, it pretty much is available to all 482 visas holders. There's also faster processing time. So for the specialist skills stream, it's expected that applications will be finalized in 7 days. Core skills stream applications will be finalized in 21 days. We're yet to see this in practice, but there have been a few applications that do come through within that time period. Lastly, the salary threshold, as I mentioned earlier, they will be indexed annually. So both the core skills and the specialist skills income threshold will increase in the next financial year. So I'll go through the visa conditions as well. So this visa condition 8607 will apply to the primary visa holder only. There are work limitations that they will need to comply with. So they'll need to work only in their approved role, the occupation and role that was approved in their most recent nomination application, unless there's an exemption that applies. So an exemption, for example, would be for certain medical occupations where they can work for different employers at the same time. If there are any changes to their role and it continues to align to the same nominated occupation, then it must be notified to the Department of Home Affairs before they begin in the new role. If the new role aligns to a different occupation, then a new nomination and visa will need to be granted before they start work. But if it's a temporary change, like a secondment or covering for a colleague that's going on leave temporarily, then it's not considered a breach of visa conditions. It's generally all okay for a few months. Applicants will also need to only work for their approved sponsor or associated entity of the sponsor. If the sponsor changes, but they're in the same occupation, then a new nomination will need to be granted before they start work. If they do cease work with their sponsor, then they will have 180 days to work for any other employer in any role until they find a new sponsor or they apply for a new visa. They can do that as long as it's a total of 365 days across their visa grant period. So they can be working without an approved nomination for a total of 365 days. They'll also need to start work in Australia within 90 days of arriving in Australia. If the visa was granted while the individual was in Australia, then they'll need to start within 90 days of the grant of their visa. Throughout the visa stay period, the individual would also need to maintain their mandatory license, registration, or membership if this was required for their occupation. So these visa conditions apply not just to the primary visa holder, but also to all their dependents as well. So everyone will need to maintain adequate health insurance while in Australia. This will need to be arranged prior to arriving in Australia, and it needs to be in effect on the day that they arrive. If the applicant is from a country where Australia has a reciprocal healthcare agreement, such as the UK, Ireland, then they may be eligible to apply for Medicare while they're in Australia. They will still need to arrange health insurance to show that they meet that visa condition, but upon entry to Australia, they can then apply for Medicare. So adequate health insurance is defined on the department's website. So they mainly include having cover for public hospital, pharmaceutical, medication, ambulance service, etc. Another visa condition that they need to comply with is that they must not become involved in activities that are disruptive to or violence threatening harm to the Australian community or a group within the Australian community. So going back to the sponsorship, as a sponsor, the business must comply with its sponsorship obligations. So we've provided a list here you can have a look at. An obligation, one of the obligation is to ensure that the equivalent terms and conditions of the employment, so the 482 visa holder must continue to be paid equivalent to an Australian worker, and their salary must not decrease from the approved nominated amount. If it does, then a new nomination will need to be applied for and granted for that new salary. So this could occur where their hours have reduced, but the salary has maintained the same. But if you calculate it, then the salary technically have reduced. They must also continue to have access to annual leave, sick, personal, or parental leave as well. The sponsor would also need to keep records to show that they remain compliant with their sponsorship obligations. One of these obligations that are quite important is if certain events occur, they need to be notified to the department within 28 days of it occurring. So this includes changes to the sponsor's details. So if the name changes, any registration details changes, business structure, or directors being appointed, then you'll need to notify the Department of Home Affairs. Generally, the easiest way to remember is if you're notifying the ASIC about any changes, then it'll also need to be notified to the Department of Home Affairs as well. With a sponsored employee, they will need to notify if there's any changes in their work duties, if they were to cease employment, or if they didn't start work on the 482 visa at all. Like I mentioned before, if an individual ceases employment, they will have 180 days to find a new sponsor, apply for another visa, or depart Australia. If they do depart Australia and they submit a written request to the business to cover travel costs, so these are reasonable and equivalent costs equivalent to the economy flights, then the business will have to cover these costs. Any non-compliance with sponsorship obligations can lead to penalties, cancellation of the standard business sponsorship, or even bans on future sponsorship in the worst case scenario. So it's really important that businesses are aware and across all of these obligations. So leading on, in order to assist with complying with sponsorship obligations and ensure that the business is not in breach, we strongly recommend that when you onboard a foreign worker, you conduct a visa entitlement verification online check. So that's a VIVO check, and that can be accessed through the department's website. We also recommend that businesses continue to do these checks throughout the employee's time with the business to make sure that they continue to hold work rights at every point. Through a VIVO check, you can confirm the type of visa that the individual holds, their visa expiry date, and any specific visa conditions, including any restriction to their work rights. You will first need to get a copy of their passport or their current Australian visa grant letter so that you can enter their names, date of birth, and passport details, or their visa grant reference number into the system. Once you've entered the details on the website into the system, just letting someone in. Once you've entered the details on the website and click submit, it will show the current visa they hold and, if applicable, their work entitlement. So if it's an unlimited work rights, it will show unlimited entitlements, which means they can work for the business. Once you have a copy, we would recommend also saving it on file and doing those regular checks. So there are 2 screenshots there that shows what it looks like on the VIVO check. So the first picture on the left, you can see you got to enter all those details in there. And on the right, it will show you what the conditions are. So this particular individual has unlimited entitlement, so they have unrestricted work rights. So I'll go through now the frequently asked questions about the SID visa and the employer-sponsored program. So the biggest question we receive is, what if the individual has lodged a SID nomination before the changes come in on the 7th of December 2024? So nominations that are lodged before that date without a visa application can still be linked to the visa. If both nomination and visa applications were submitted before that date, they will be assessed under the previous TSS visa requirements. So they're still valid, and you don't need to make any changes unless something has changed since then. Can the individual apply for more than one SID visa? Yes, there are no restrictions on the number of SID visas you can apply for, as long as you can meet the eligibility requirements. Can the individual count casual employment to the skill level requirement? Yes. Since the SID visa came in, you can count casual, part-time, or full-time employment as long as it is paid and relevant to the nominated occupation, and it's within the past 5 years. It doesn't need to be continuous employment. All you need to do is show that you have a total of 1 year of full-time equivalent work experience before you submit your SID visa application. Do I need to do an English language test? So yes, the visa applicant will need to do an English language test unless they meet any of the exemptions below. So this means holding a valid passport from the UK, US, Canada, New Zealand, or Ireland, if they have completed at least 5 years of English studies in a secondary or higher education institution, if they are nominated in an occupation that requires them to obtain registration, license, or membership, and they were required to demonstrate a level of English proficiency that is equivalent to what's required for the SID visa, then they can use that as evidence. Lastly, if they are an intra-company transfer, so transferring from an overseas associated entity to the sponsor, and they will be earning above 96,400, they can be exempt from the English language test as well. So I've also outlined the language test requirements for the SID visa. As I mentioned, it's now vocational level. Previously, it was 2 different levels, the functional and the vocational level. So now all the applicants need to show for an IELTS, for example, they will need to score at least 5.0 with a score of at least 5 in each of the test components. With an occupational English test, they'll need to show at least B in each of the 4 components, TOEFL IBT at least 35, with a score of at least 4 for each of the test components, for listening and reading, 14 for speaking and writing. PTE at least 36, with a score of at least 36 in each of those test components. Cambridge English Advanced, they will need a score of at least 154 in each of those test components as well. Another question we usually get is, what happens if, can I change employer on a SID visa, and what happens? So yes, an applicant or an individual can change employer while they're holding a 482 visa at any time, that they will need to transfer their nomination to their new employer or sponsor before they start work. So a new visa will also need to be applied for if they will be working in a different occupation to what has been approved on their current visa. Nominations can only be lodged for occupations that are on the CSOL, or if it's not on the CSOL and they're earning above 135,000, they can lodge under the specialist skills streams. If they have ceased work, and as part of their visa conditions, they're not able to find a sponsor, then they can still work for any employer for up to 180 days. If they're not able to find or transfer the nomination within that 180 days, then they will need to apply for another visa or make arrangement to depart Australia. The other question is, can they work for another employer while on the 482 visa? So concurrently, while they're working on the 482 visa. If they're working for the sponsor, they cannot be working for another employer unless the work is undertaken for their sponsor and in their nominated occupation. For example, a side project or a temporary secondment is okay. Or if it's unpaid voluntary work, then that's fine as well to do at the same time as their 482 full-time work. Is the individual still eligible for a PR? Yes, they will still have access to employer-sponsored PR through the employer nomination scheme, the Subclass 186 visa program. So the 2 main streams will still apply. So for the temporary resident transition TRT stream, They will need to show that they have at least 2 years of full-time employment in their nominated occupation with an approved sponsor in Australia while holding a 482 visa. And this can be within the last 3 years. For the direct entry stream, the occupation must be what's listed on CSOL to be able to be eligible for DE stream. The applicant would also need to obtain a positive skills assessment for their nominated occupation unless there's an exemption. So an exemption, for example, is if they're an academic applicants, science applicants, or if they're a subclass 444 or 461 worker. And they will also need to meet at least 3 years of full-time relevant experience. So as a 482 visa holder, when am I eligible to lodge a 186 visa? So generally, you are eligible to apply for a 186 visa when you have worked with an approved sponsor for at least 2 years, full-time in the approved nominated occupation while in Australia and excluding any days of unpaid leave. There is now added flexibility to the eligibility date, so the individual does not need to be employed with the same employer or sponsor on the 482 visa for the whole 2-year period. Instead, they can count time with other sponsors on the 482 visa as long as it was an approved nomination. There was an approved nomination with a sponsor, and in the same nominated occupation, minus any unpaid leave. So unpaid leave would push that eligibility date back. So if they're eligible today, but they've taken 2 days of unpaid leave, then their eligibility date will then be in 2 days. What if the 482 visa expires before the 186 eligibility date? So if the 482 visa is expiring a few days before the individual is eligible for the 186 visa, there is immigration policy that allows them to submit a 186 visa application to prevent the efficiency of applying for another 482 visa. A few days is not defined explicitly, but generally it is taken to be less than 5 days. There is obviously risks to the application if, for example, the case officer is not satisfied that this requirement is met. They have the discretion to refuse that 186 visa. So to avoid this risk, we would generally recommend, if possible, for a 1-year 482 visa to be submitted before the visa expiry date so that they can bridge that gap until their 186 eligibility date. They can minimize the cost of the application by doing a 1 year instead of a 2, 3, or 4 years, given that they'll likely apply for the 186 visa in the near future. But at least it bridges that gap and ensure that that individual is meeting all of the requirements before they submit the visa. So the current processing times at the moment, the main effects of SID coming in is to streamline that process and to have a shorter timeframes. But based on the department's website that I checked, I think a few days ago, it should still be the same, is for a SID visa, under the core skills stream, it's about 4 to 6 weeks now. Specialist skills streams is about 2 to 5 weeks processing times. The department has acknowledged that there is a big backlog of applications. So most new SID visas that are lodged since 7th of December, when the new changes came in, have been meeting the promised processing times. But it looks like the 482 visas lodged before December 2024, their processing times still remain around the 3 to 6 month mark, which is a big difference. Our understanding is that there are currently 2 processing teams working on the applications, one processing pre-December 2024 applications, and where extra resources have been allocated to address the backlog. Another team is processing those lodged after December 2024. The new applications are subject to a shorter service standard, where it is a complete application, so health and police clearances and all the requirements are met and lodged with the application. Similarly, with the Subclass 186 visa, the employer-sponsored PR visa, there are delayed processing times. It is at the moment 13 to 18 months of processing times. They are prioritizing certain occupations, such as those in the healthcare industries, but there's really sort of no indication or guarantee that they will be processed at a quicker rate. And finally, the biggest question or the most common question we also get is, what are the fees a sponsor must cover? So for a SID visa, the payment arrangements are quite strict. The sponsor must cover any fees that are associated with the nomination application. So this generally is 50% of the professional fees. They must cover nomination, part of the government lodgement fee, and the Skilling Australians Fund levy. The visa application costs, so these will be the other 50% of the professional fees. Visa government lodgement fees can be paid by the applicant directly, provided that these costs do not fall within the banner of recruitment costs. For example, if the business agreed to pay all costs associated with the SID visa as an incentive for the applicant to accept the role, these costs would then be considered recruitment costs, and the sponsor would have to cover them as part of their obligation. For the 186 visa, it is less restrictive. The sponsor must cover as a minimum the Skilling Australian Fund levy only, which is the $5,000. So before we wrap up, I just wanted to take a moment to share how our firm can support you with your immigration needs. So we do provide strategic immigration advice, helping businesses and individuals understand their visa options and policy changes to make informed decisions. We also offer end-to-end visa management, guiding you through the entire process from preparing and lodging applications to navigating any changes that arises during the processing of that visa application. For businesses, we assist with workforce monitoring and training, ensuring that your sponsored employee remain compliant. And we also offer training sessions regularly to help HR teams stay up to date with any changes that come in, or if they just need a refresher on any requirements at all. Finally, we also help with sponsorship and compliance, providing advice on employer obligations, monitoring compliance, and minimizing any risk to the business from an immigration perspective. So if you do need any assistance or have any questions about how we can help, feel free to reach out to us. So we're now gone to the end of the session. And just wanted to ask if there are any time. Yes, there is. There's about a few minutes. Any questions so far on the information we've covered today? Let me check the chat function. So someone asked if the time under a subclass 400 visa also count towards PR, or if only counts if you're under a 482 visa. So it depends which stream for the PR 186 visa you're applying under. If you're applying under the TRT stream, you can only count time that you have worked with a sponsor on the 482 visa. But if you're applying under a direct entry stream, for example, then experience throughout your work history can count towards the 3 years that's required for the direct entry stream. I don't think there's any more questions there. Cool. If there's no more questions, thank you everyone for attending today's session. Oh, there is one that popped up. If I change roles within the same company, but my new position still falls under the engineering professionals category in the seesaw, do we need to update the 482 visa? If your new position still falls under the same nominated occupation, then all that needs to be done from a business perspective is to notify the Department of Home Affairs that there is a change in your duties. So that notification needs to be submitted by your business as part of their sponsorship obligations. And that needs to be submitted before you change roles. But otherwise, you don't need to update your 482 visa. Cool. I'll just give it a few moments in case anyone has any question that will pop up. So while that's going, a recording of this session will be shared in the coming days. So if you want to keep an eye out for the email that will come through. We also have tons of free resources on our website on the SID visa and many other visa types. So if you have any questions or need any specific query that needs help with, feel free to drop us an email or give us a call at the number on the right side. Otherwise, feel free to subscribe to our newsletter as well for any regular immigration updates. The link is there, or you can just go to our Google Hannan Tew Lawyers and it should pop up on our homepage. Cool. It doesn't seem like there's any more questions. So thank you everyone for attending. And I guess that's 6 minutes back into your life to chill for a bit. Thank you, everyone.